In this lecture, we shall continue with our discussion on vitiating factors. We shall continue with our discussion on vitiating factors. Now, by way of a recap, in the previous lecture, we introduced the discussion on vitiating factors. And we explained that vitiating factors are factors which could negate the apparent consent of one or both parties to a contract. We mentioned that vitiating factors are the factors that could negate the apparent consent of one or both parties to a contract. And therefore, when you're able to establish a vitiating factor, it renders the contract unenforceable in some respects. It renders the contract unenforceable in some respects. In other words, vitiating factors are those legally recognized factors like mistake, misrepresentation, undue influence, that when you are able to establish, they make a contract lose its validity when it comes to enforcement. So you recall that you've already dealt with the elements of a valid contract, which once they are present, they will make a contract enforceable. But for the vitiating factors, if you're able to establish them, they make an apparent contract lose its validity. Now, the vitiating factors that we are set to discuss are mistake, misrepresentation, duress, undue influence, and unconscionability. Now, the first discussion that we intend to have is referable to mistake as a vitiating factor. Referable to mistake as a vitiating factor. Now, bear in mind that for mistake as a vitiating factor, for you to fully understand it, there are some two key terms that you have to understand. That is, you have to understand what it means to say a contract is void. And you also have to understand what it means to say a contract is being rendered voidable. When we say a contract is rendered voidable, what it means is that that contract will remain valid, but by virtue of some defect or some circumstances affecting the contract, the contract will remain valid unless steps have been taken to set it aside. In other words, when a contract is declared as voidable, it means that the contract is one which will be valid unless and until steps are taken to rescind or avoid the transaction by the innocent party. And therefore, that is what we mean to say that a contract has been rendered voidable. But when we say a contract is void, what we mean is that that contract does not confer any rights on the parties. The contract is deemed to be a nullity. And if it's a nullity, it is deemed not to confer any rights whatsoever on the parties involved. So the distinction between a void contract and a voidable contract is that whereas the void contract is deemed to be dead on arrival, it is deemed as though the contract was never in existence. The voidable one actually takes the position that the contract will remain valid unless steps have been taken to set it aside. Now, the first type of mistake we are dealing with, because we mentioned that for mistake as a vitiating factor, there are three different types. That we can have mistake as to title, we can have mistake as to quality, and we can have mistake as to, or we can have a unilateral mistake, we can have a common mistake, and then we can also have a mutual mistake. Yes, so please take notes. The types of mistake that we have to look at, there are three types. We'll be looking at the mutual mistake, we'll be looking at the unilateral mistake, and we'll be looking at the common mistake. So three types of mistake. Unilateral mistake, we'll be looking at the common mistake, and then we'll be looking at the mutual mistake. So mutual mistake, unilateral mistake, and then common mistake. So the topic we are supposed to discuss now, the particular type of mistake we are supposed to discuss now in this lecture, is unilateral mistake, unilateral mistake. Now, what do we mean by unilateral mistake? So for unilateral mistake, what in essence we are referring to is that the mistake is actually made by just one party to the contract. That is why it is described as a unilateral mistake. Only one party to the agreement makes the mistake, and then the other party is usually aware of the mistake and seeks to take advantage of this particular mistake. One party is making the mistake, the other party is usually aware, keeps quiet, and intends to take advantage of that particular mistake. So a typical example is a person who we shall for this purpose describe as a rogue. A rogue entering into a particular shop and then describing himself to be, let's say, the Minister of Finance. And then based on that representation, which is false, the rogue then goes ahead to make an order for goods and services. Or make an order for some goods that I want to buy 100 pieces of this particular watch. Then he gives the shop seller a check. Now the shop seller gave the check thinking that the person that he's giving the watches to is the Minister of Finance. In other words, the shopkeeper is making the mistake, but it is only the shopkeeper that is making the mistake, because the rogue is aware the shopkeeper is making the mistake. The rogue is aware that the shopkeeper is not the owner. The shopkeeper is not aware that he's not the Minister of Finance, but the rogue still goes ahead to give the check, create the impression that he's the Minister of Finance, and allows the shopkeeper to give him the watches, which he now takes away. Now, this becomes a unilateral mistake because it is only one party to the contract which is mistaken, i.e. the seller. The rogue, who is aware that the innocent party is making the mistake, but the rogue himself makes no mistake at all. And this rogue, in this case, is even aware of the seller's mistake, that the seller is making a very huge mistake, but the rogue seeks to take advantage of that seller's mistake. So that is what we mean by unilateral mistake. Unilateral mistake, only one party is mistaken, the other party is usually aware of the mistake and insists to take advantage of it. Now, as I've indicated, there's a very common type of unilateral mistake, and that is mistake as to the identity of a contracting party. This will form the focus of a lot of our discussions. Mistake as to the identity of a contracting party. So now what we have to do is to find out what we mean by mistake as to the identity of a contracting party. It falls just within the example and the scenario that I just gave. But let us see how the authorities have defined mistake as to the identity of a contracting party. And I'll refer to the rendition given by A1 McKendrick in his book Contract Law, 15th edition, at page 62. This is what the learned author says about mistake as to the identity of a contracting party. Mistake as to the identity of a contracting party. This is what the book says. The identity of the person with whom one is contracting or proposing to contract is often immaterial. A simple example is provided by the sale of goods in a shop. The owner of the shop will often be indifferent as to the identity of the person purchasing the goods. What matters is not the identity of the customer as such, but his willingness and ability to pay for the goods. But let us suppose that the customer wishes to pay for the goods by check or credit card. This may change matters because if the customer is not who he says he is, the shop may find that his demand for payment on the check or his demand for payment from the credit card company will be rejected, and it must then be looked to the defaulting customer for redress. Again, but let us suppose that the customer wishes to pay for the goods by check or by credit card. This may change matters because if the customer is not who he says he is, the shop may find that his demand for payment on the check or his demand for payment from the credit card company will be rejected, and he must then look to the defaulting customer for redress. redress. Even here, however, the identity of the customer does not generally give rise to legal difficulties, as between the shop and the customer. It may, of course, give rise to considerable factual difficulties in terms of ascertaining the true identity of the customer. But such difficulties are not our present concern. The customer, whoever he is liable to pay for the goods he has acquired. The legal difficulties then tend to arise in the case where the customer sells the goods which he has purchased to a third party who pays for the goods in good faith. That is to say, he is unaware of the circumstances which surround the earlier transaction. Let me pause here and take a critical look at the statements. The customer, whoever he is liable to pay for the goods he has acquired. The legal difficulties tend to arise in the case where the customer sells the goods which he has purchased to a third party who pays for the goods in all good faith. That is to say, he is unaware of the circumstances which surround the earlier transaction. This is what the author is saying. The mistake as to the identity of the contracting party would usually arise when a person gets into a shop, describes himself to be a different person, and then makes an order for goods. The learned author is saying that at that point in time, whoever the customer is of no concern to the seller, because all the seller wants is his money. But it becomes a problem for the seller if you claim to be a particular person. And then it's only because you claim to be this particular person, that's why the seller agreed to accept a check. Now, if you are a rogue, if you are impersonating the person, it means that when you pay the seller with a check, and the seller gives you the vehicles, and you go out with the vehicles, by the time the seller goes to present the check to the bank, the check can end up bouncing. Now, how will the seller get the vehicles? Over here, too, is not a problem, because all the seller must do is to contact you, the buyer, and get a vehicle from you. But the problem will arise when you, the buyer, after defrauding the seller, you went ahead to sell the car to an innocent third party who bought the car for value, in good faith, and without knowing that you, the person, you are a rogue. In such cases, the defaulting customer is usually a rogue or a thief. He had no intention of paying for the goods at the time of the acquisition from the original owner, and he sold them on to an innocent purchaser almost immediately after acquiring them. In the typical case, by the time that the owner discovers the true situation, that is, he will not be paid by his customer, the goods have already been transferred by the rogue to the possession of a third party. Again, let me take this portion of the author again. The author, the learned Ewan McKendrick, is stating that in such cases, the defaulting customer is usually a rogue or a thief. He has no intention of paying for the goods at the time of the acquisition from the original owner. And therefore, as soon as he comes to give you the fake check and you give him the vehicle, because he wants his money, he'll quickly sell the vehicle to a third party, and then he, the rogue, will just vanish. Now, by the time you, the owner, realize that the check has been bounced and has been returned and is honest, when you are now getting back to the rogue, you may not find him, but you may find the car in the hands of a third party. Now, given that, now the author continues, that is Ewan McKendrick, and I quote, given that a claim against a rogue is unlikely to be fruitful, either because he cannot be found or because he has been found and is not worth suing, the original owner is likely to wish to bring the action against a third party in possession of the goods. In essence, the claim of the original owner is that he remains the owner of the goods and is entitled to have them back or their financial value. So the owner of the items, usually because he can't even see the rogue again, he can't find the rogue again, he'll find the car in the hands of a third party, and the owner is going to claim that the car belongs to him to bring back his car. Now the learned author continues. The innocent third party would generally respond to the effect that he is the owner of the goods, having bought them in all good faith. So as the owner of the items, the original seller, is saying that give me back my vehicle because the vehicle belongs to me. This third party too will say that no, I also bought it in good faith from the rogue. I didn't know he came to defraud you. He showed me the documents. That's why I bought it from him. So between the seller and then the third party, who would have superior rights over that particular item? Now, the third party, as I've indicated, will generally deny the claim on the ground that he is the owner of the goods, and therefore the actual owner should not be able to bring the right to recover the goods from the seller. This brings us to the scenario and the diagram that you can see on the screen. And an understanding of this particular diagram would make the remaining portion of this particular topic very, very easy. Once you understand this portion, this diagram, it makes everything very easy. So now take a look at this diagram. Now you'll see that there's a seller here. There's a rogue here who has deceived the seller to acquire the item. So the rogue went to the seller's shop, and when he told the seller that he is the Minister of Finance, he gave the seller a check. Then the seller gave the goods to the rogue. Then the rogue quickly transferred the goods to the third party over here. And now at the time that he transferred to the third party, the seller too is presenting the check to the bank. So now when the seller realizes that the goods, the check has been dishonest, this rogue can no more be found. This rogue can no more be found. But the seller has traced and been able to find the car in the hands of this third party. Now the seller is now suing the third party to recover those goods. The question is whether the seller can recover the goods from the third party. This is how the mistake as to the identity of the contracting party usually plays out. And we'll be referring to this diagram a lot whenever we see the actual cases that relate to unilateral mistake. It says that the seller has been deceived by the rogue to acquire some goods by a fraudulent misrepresentation. Quickly transfer the goods to a third party. Now, the seller wants to recover the goods from this third party. As to whether he can recover or not depends on the transaction between the seller and the rogue. Now, pay critical attention to this diagram. Remember, the seller here is the one trying to recover the goods from the third party. And the question is whether the seller can recover the goods from this third party. Now, what you need to bear in mind is that as to whether the seller would be able to recover from the third party or not, it depends on whether the contract between the seller and the rogue, whether it was void or it was voidable. As to whether the seller would be able to recover the goods from the third party, it depends on whether the transaction between the seller and the rogue, whether it was void or it was voidable. Why am I saying this? Now take a look at the diagram again. We are saying that the rogue acquired the goods from the seller, quickly transferred it to the third party, and the rogue has vanished. The seller has found the goods in the hands of the third party and wants to recover it. We are saying that as to whether he can recover it, it depends on whether the transaction between the seller and the rogue, whether that transaction, it is void or it becomes voidable. And why am I saying so? If the transaction between the seller and the rogue, if it is void, would the seller be able to recover from the third party? Pay critical attention to the scenario we are discussing. Look at the diagram carefully. Now, if the transaction between the seller and the rogue has been declared to be void, it means that the transaction between the seller and the rogue itself has been held to be void. Would the seller be able to recover the goods from the hands of the third party? The answer is yes. The answer is yes because when the transaction between the seller and the rogue is held to be void, it means that the rogue would have acquired no title at all to the goods. And if the rogue acquires no title to the goods, then it means that whatever title the rogue would have acquired will become zero. And if it is zero, whatever the rogue also gives a third party to becomes zero. Because if it is something is void, void means that it is deemed as though the transaction was even never in existence. So if the transaction is treated as one that was even never in existence, it means that you, the rogue, you acquired no title whatsoever under that particular transaction. So if the contract between the seller and the rogue is declared to be void, then it means that whatever is happening between the seller and the rook, it turns out to be void. And if it is void, whatever the rook 2 gives to the third party 2 also becomes void. So if something is void, it means that it is deemed as though it was never even in existence. So whatever the seller gives to the rook, as you can see in the diagram, we have written 0 against that place because it is void. Void means that it was deemed as though it was even never in existence. So whatever title the rook would also give the third party to becomes what? 0. So title continues to remain in the seller. So take note of this particular point, that for a lot of these cases, this is how you are going to analyze them. You see a rook who deceive a seller to acquire a particular product, then the rook will give a dark check, and then when the check is presented, it will be dishonored. By the time that the seller realizes that the check has been dishonored, the rook has already transferred the goods to the third party, and the rook has vanished. As to whether the seller can recover the goods from the third party or not, it depends on whether the transaction between the seller and the rook is void or it is what? Voidable. If it is void, as I have indicated, it is deemed as though the transaction was never even in existence. And if it happens that way, it means that whatever title the rook acquires becomes void, and therefore the rook gives it to the third party. Whatever the rook gives to the third party too becomes void. So the seller will be able to recover the goods from the third party. When we say the transaction between the seller and the rook is voidable, what does that one also mean? And what situation does that one to create? That the transaction between the seller and the rook is voidable, what does that one to mean? If it is voidable, as you can see on the screen, if the contract between the seller and the rook is voidable, it means that the contract will be valid unless and until the seller takes steps to repudiate the contract before the rook transfers the title to a third party who buys the item for value in good faith and without notice of the rook's defective title. Pay a critical attention to the diagram you have on the screen now. Take a critical look at it. Same scenario. The rook goes ahead to acquire goods from the third party, and as acquiring the goods from the seller, the rook now goes ahead to quickly transfer the goods to the third party. And our question is that if the transaction between the rook and the seller is voidable, and the seller recover the goods from the third party? It depends. It depends on, because by voidable, what we mean is that the transaction will remain valid unless and until the seller takes steps to repudiate the whole contract before the rook transfers the title to a third party who buys them for value in good faith and without notice of the rook's defective title. Now, why am I saying this? Why am I saying it depends? It means that if at the time that the rook transferred the item to the third party, the seller had not rescinded the transaction, it means that the title to the rook will become a valid title. I put valid title here. So if it's a valid title, whatever the rook would also give to the third party would also be a valid title. So now the seller would then now have no title, as you can see on the screen. Because if it is voidable means that it remains valid unless and until steps are taken to rescind it. So if the seller transfers it to the rook and a voidable transaction, it means the seller will lose the title and it will now go to the rook. So the rook will have a valid title. So if the seller has not rescinded before it is given to the third party, then the third party to acquire a valid title, it means that the seller cannot recover the goods from the third party. But if the seller goes ahead to rescind this transaction, then when he rescinds, the rook title will now become 0, then the title will now come back to the seller. That is if he rescinded before it was given to the third party. In other words, if the transaction is voidable, it means that it will remain valid unless and until steps are taken to rescind it. It means that if it is voidable, it means that the rogue would acquire a valid title unless the seller takes steps to rescind it. So if the rogue transferred to a third party who acquired it for value in good faith, without knowing that there was a defective title, then it means that since the rogue has transferred it to the third party, at the time when the transaction has not been rescinded, the seller will be able to recover from the third party. This becomes clearer if you take a look at this diagram. And the principle above it says that if the contract between the seller and the rogue is voidable, and the rogue transfers the item to a third party who buys it for value in good faith, and without notice of the rogue's defective title, at a time when the owner has not rescinded the contract, the third party will acquire a valid title to the goods. So take a critical look at the diagram again. Now, bear in mind, the focus over here is that at the time when the transfer was done, the seller had not rescinded the entire transaction. The seller had not rescinded the entire transaction. So if you have not rescinded, it means that the rogue will end up acquiring a valid title to the goods. So if the contract between the seller and the rogue is voidable, and the rogue transfers the item to a third party who buys it for value in good faith, and without notice of the rogue's defective title, at a time when the owner has not rescinded the contract, the third party will acquire a valid title. Now, what do you mean by this? Look at the diagram here. Rogue deceives the seller, acquires the item, quickly transfers to the third party, and vanishes. Remember, as we have said, if it is a voidable transaction, then from the time of transfer, the rogue would acquire a valid title. And the seller will have no title. Now, if it is given to the third party to acquire a valid title, so the seller's title now becomes zero. So if it is zero, seller cannot recover from the third party. If you are not understanding, then this is the whole reason why you are doing mistake. Because the whole topic about mistake is about these diagrams. So that when you see any question, we'll try to situate it within this context and see whether we understand it or not. This is what A1 McKendrick then states. And when I read this statement, you will understand why we are learning mistake as a topic in contract law. This is what he says, A1 McKendrick in his book Contract Law, 15th edition at page 63. This is what he says. Turning to the contract between the original seller and the rogue, there's clearly something wrong with it. The rogue has assumed a false identity and would generally be guilty of fraud. In many cases, he will have induced the seller to enter into the contract by a fraudulent misrepresentation as to his identity. The important point to note here is that fraudulent misrepresentation renders a contract voidable. That is to say, the contract remains valid. Again, the contract remains valid and can operate to transfer ownership in the goods until such time as the contract has been set aside. I'll take that portion again. The point over here to note is that fraudulent misrepresentation renders a contract voidable. That is to say, the contract remains valid and can operate to transfer ownership in the goods until such time as the contract has been set aside. This does not represent an attractive option for a seller because the rogue will, in all probability, have transferred the goods to an innocent third-party purchaser before he has had the opportunity to discover the truth and set aside the transaction with the rogue. Again, this does not present an attractive option to the seller because the rogue will, in all probability, have already transferred the goods to an innocent third party before he, that is the seller, has had the opportunity to set aside the transaction with the rogue. On this basis, the innocent third party would win because he would acquire ownership of the goods from the rogue. A more attractive option from the perspective of the seller is to assert that the contract with the rogue was void on the ground that it had been entered into under a mistake. Mistake can operate to render the contract void, and the contract which is void is set aside for all purposes and generally produces no legal rights whatsoever. So if the contract was void for mistake, the rogue would have not obtained property in the goods from the original seller, and therefore he has no property in the goods to pass on to the innocent third party. On this basis, the seller will win and will be entitled to recover the goods, or more likely their financial value from the third party. I'm taking the portion again. A more attractive option from the perspective of the seller is to assert that the contract with the rogue was void on the ground that it had been entered into under a mistake. Mistake can operate to render the contract void, and a contract which is void is set aside for all purposes and generally produces no legal effects whatsoever. So if the contract is void for mistake, the rogue will not have obtained property in the goods from the original seller, and therefore he has no property rights to pass on to the innocent third-party purchaser. On this basis, the original seller will win and will be entitled to recover the goods, or more likely, their financial value from the third-party purchaser. Now, this is what this point is stating. The point is made here brings us to this diagram, that if you are the seller in this particular case, would you want to argue from the perspective that the contract is void or it is voidable? Ewan McKendrick is saying that the seller would like to argue that the contract was void. Because for the seller, if it was void, it means that whatever happened between the seller and the rogue conferred no title to the rogue. And therefore, whatever the rogue to gives the third party to becomes no title, and therefore the seller will be able to recover it. So he's taking the position for the seller. It would be better for the seller to argue that the transaction is void. Because for the seller, if it is void, it means that what he gave the rogue, it becomes of no effect. And therefore, whatever the rogue to gives the third party to becomes of no effect, and the seller can recover from the third party. But from the third party will be arguing that the transaction between the seller and the rogue was voidable. And if it was voidable, it means that it was valid unless steps were taken to rescind it. So since the seller had not rescinded before the rogue gives the third party would have acquired a valid title. That is why Ewan McKendrick mentions over here that a more attractive position from the perspective of the seller is to assess that the contract with the rogue was void on the ground that it had been entered into under a mistake. Mistake can operate to render a contract void, and a contract which is void is set aside for all purposes and generally produces no legal effects whatsoever. So, if the contract is void for mistake, the rogue could not have obtained property in the goods from the original seller and therefore has no property rights to pass on to the innocent third party. On this basis, the seller would win and will be able to recover the goods, or more likely their financial value, from the third party purchaser. So this is the whole reason why I'm learning mistake as a topic. Because for this unilateral mistake, many of the questions that we'll see will be that the rogue had entered into somebody's shop, deceived the shop owner, taken goods, given to a third party, and then has run away. Owner has found the goods in the hands of the third party and wants to recover. My statement to you is that as to whether the owner can recover from the third party is dependent on whether the contract with the rogue was void on grounds of mistake or was voidable. If it was void, it means the transaction conferred no rights, and therefore the seller would be able to recover. But if it was voidable, it means that it will remain valid unless steps are taken to rescind it. And therefore, that will make the transaction voidable. This is very important for you to get because this is what actually makes you understand the whole topic of unilateral mistake. So when you are reading every case, we'll approach the case within this particular context where you're looking at three parties: seller, the rogue, and then the third party. Once we get it that way, and you understand that if the transaction between the seller and the rogue is void, then the seller can recover from the third party, the whole topic becomes very easy. Let's see what the learned scholar Christine Dowuna Hammond, in her book, The Law of Contracts in Ghana, says also at page 194 and then 195. The learned Ghanaian author Christine Dowuna Hammond, in her book, The Law of Contracts in Ghana, at page 194 and 195. The statement over here that she makes in the book makes it very easy to understand that whole topic of unilateral mistake. This is what the learned author states. If it is established that there was a mistake as to the identity of the contracting party, the resulting contract is deemed void. This means that the rogue does not acquire any legal title or right of ownership to the goods. In accordance with the Nemo Dat Code non habeas rule, which stipulates that a person cannot transfer to another a better title than he himself possesses. It follows that if the rogue acquired no title to the goods, then he could not legally have transferred any title to the innocent third party, even though the third party gave value and acted in good faith and without notice of the rogue's lack of title. This point she makes is very, very instructive. Like I said, it's when you understand this, then the whole topic of unilateral mistake becomes very easy for you to understand. Say that if, and this is from a book at page 194 and 115, if it is established that there was a mistake as to the identity of the contracting party, the resulting contract is deemed void. What does this mean? Now, once you can prove mistake as to the identity of the contracting party, it makes the agreement void. And what does it mean to say that it is void? She continues. This means that the rogue does not acquire any legal title or right of ownership to the goods, and that in accordance with the nemo dat code non habet rule, then it means that whatever the rogue to give to the third party to becomes of no effect. And that's what brings us to this diagram that I showed you first. That if the transaction between the seller and the rogue is void, then it means that whatever the seller gives the rogue is zero, whatever the rogue to give the third party to is zero, so the owner may be able to recover from the third party. So that's why we are learning this unilateral mistake topic. So for all the questions that we will look at, our goal will be to find out whether or not we can establish mistake as to the identity of the contracting party. Because as we have been told in Christian Dolan and Hammond's book, it says that when the transaction is declared to be void on the grounds of, it says that if you're able to establish a mistake as to the identity of the contracting party, it makes the whole contract void. So our goal, when we look at the cases, will be to find out whether or not we can see a mistake as to the identity of the contracting party. Because if you can see that one, it will make the agreement void. The agreement between the owner and then the rogue will be void. And therefore the owner will be able to recover from the third party. So Christian Dolan Hammond concludes as follows. The conclusion would therefore be that the third party will obtain no title to the goods, and the original owner would be entitled to recover the goods from the third party. The third party's only remedy will be to look for the rogue if he can find him and sue for his money. Now, bear in mind, as I have said already, from Christian Dolan Hammond's book, we've been told that when you have been able to establish a mistake as to the identity of the contracting party, it makes the whole contract void. How would we then be able to establish a mistake as to the identity of the contracting party? How do we establish a mistake as to the identity of the contracting party? We can establish mistake as the identity of the contracting party when you meet some particular thresholds. But take note of this, and you'll see this also from Christian Dolan Hammond's book. Look at the statements from Christian Dolan Hammond's book. A mistake as to the identity cannot be established, because like I've told you earlier, if you're able to establish the mistake as to identity, it will make the contract void. If the mistake as to the identity cannot be established, the resulting contract will not be deemed to be void, but merely voidable on grounds of the rogue's fraudulent misrepresentation. A voidable contract is one which is valid unless and until it is disaffirmed or avoided. In this case, the rogue will be deemed to have obtained title to the goods, even though the title is voidable. If the owner were to take steps to avoid the contract, the rogue's title will be rendered void, and the rogue will thereafter not be able to pass on its title to the third party. However, if the rogue's title has not yet been avoided by the time he sells the goods to the third party, the rogue passes on the valid title to the third party. This entitles the third party to keep the goods, and the owner cannot thereafter recover the goods from the third party. The deciding factor, therefore, is whether or not mistake as to the identity of the contracting party can be established. What are we saying? It's just false meaning the diagram I've showed you. That's the whole reason why I'm learning mistake as a topic, is to find out whether we can prove mistake as to the identity of a contracting party. Because if you can prove the mistake as to the identity of the contracting party, then it will render the contract void. If it is void, it means that the rogue didn't give anything to the third party, seller can recover. But if it doesn't render it void, it renders it what? Voidable. And if it renders it voidable, it means that we have to find out whether the transaction itself, whether the owner rescinded the transaction before it was transferred to the third party or not. This is the whole reason why we have to discuss mistake with particular reference to unilateral mistake. Now, our main focus here, as you have mentioned, is to find out that how do we establish the mistake as to the identity of the contracting party? How do we identify and how do we establish a mistake as to the identity of the contracting party? Because it's only when you have been able to establish the mistake as to the identity of the contracting party that the contract between the owner and the rook will begin to be void, and therefore the owner will be able to recover from the third party. So this will be the focus of our next lecture. We shall now find out that how would the owner be able to establish the mistake as to the identity of the contracting party? Because like I've said, once you can prove the mistake as to the identity of the contracting party, then the transaction between the owner and then the rook becomes void. Then the owner can recover from the third party. So what we have done so far in this lecture is that we have been able to find out that unilateral mistake is when only one party makes the mistake in question. And when only one party makes the mistake in question, the other party is usually aware and insists to take advantage of this particular mistake. Now, a very common way we can have this unilateral mistake is mistake as to the identity of the contracting party. And we have been told this will usually arise when one party enters a particular shop, describes himself as another person, orders goods, then gives a check. Then the seller gives him the check. Then this particular person will then run away, sell the goods to a third party, and use the rook again. The owner will present the check. The check will be dishonored. And when he wants to recover from the third party, the question will be whether the transaction between the owner and the rook, whether it was void on grounds of mistake or voidable on grounds of misrepresentation. As you have seen, from all the cases we looked at, if the transaction between the seller and then the rook is also void on grounds of mistake, can the seller recover from the third party? Remember that if it is void on grounds of mistake, the seller can recover from the third party because whatever the seller gives to the rook becomes zero. It will begin as it was never in effect, and therefore what the rook gives the third party to becomes void. So the seller can recover from the third party. So that is the whole purpose of the discussion we'll be having in our next lecture on unilateral mistake. We'll find out that under what circumstance would the court find that the contract between the owner and the rook was void on grounds of mistake. Because if it was void, it means that then the owner would be able to recover the goods from the third party. So in our next lecture, we shall find out how do we establish a mistake as to the identity of the contracting party. Thank you.